All rise. The Honorables, the presiding judge and judges of the Court of Appeals of the State of North Carolina. Oh yes, oh yes, oh yes. The Court of Appeals is now in session. God save the state and this honorable court. Be seated.
Good morning and welcome to the North Carolina Court of Appeals. We have one case on the calendar for oral argument this morning, and that's number 21-354, Spencer versus Goodyear Tire and Rubber. We've confirmed the parties are ready to proceed, and I understand because there are cross appeals here, you all have worked out the argument time, so we'll hear from the first appellant.
May it please the court, my name is Dwayne Jones. I represent the defendants in this matter, and I have stated I'd like to reserve 10 minutes for rebuttal. So I know that this case may look like an injury by accident. It's not an injury by accident. That's going to be Mr. Burdick's appeal. I know that also that it may look like an occupational disease, but it's not that either. Mr. Spencer certainly got hurt at work while he was doing his job. But that does not translate into necessarily being a compensable event. What I'm here arguing about is the full commission found that Mr. Spencer suffered an occupational disease while he was at work. But their theory of how this occupational disease came about is flawed, and it's not supported by the testimony of Dr. Spear, which is the doctor that they relied upon. Now, they outline sort of what their theory is in finding of fact 15, 16, and 17 of their opinion and award. And as best that I can summarize it, the repetitive motion of the job, the stress of the job caused Mr. Spencer to develop bone spurs, which then sort of rubbed against or aggravated the shoulder ligaments. And then somehow that process then caused his bicep tendons to become unstable. The thing is, Dr. Spear never testified that that happened.
So you would agree, like, suppose in a hypothetical that a worker is exposed at a factory to some chemical over and over, day after day, and that repeated exposure causes some sort of condition where your bones can't heal, they're broken. And then one day while out just doing the ordinary things of life, the worker breaks one of their bones. It doesn't heal, so then they can't go back to work. You'd agree that you could argue that it was the occupational disease that caused that harm, right? Because of course the bone would heal without the fact that you have this condition. It was caused through this repeated exposure at work. And I think what your friend is going to argue is that's sort of what happened here, that it was the bone spurs and the other degenerative issues that their expert says these are the occupational disease that's in combination with the acute event caused the injury. So address that argument that I think we'll hear.
Okay, well, I'm not going to entirely agree with you, and you asked me that I would agree. I don't know that I would entirely agree. I think it's certainly possible, and I think that you just said something that is missing in this case, and that is a causal connection. What you just said about the bone spurs is what the full commission said. Yeah, the bone spurs cause the shoulder to go bad, and then that sort of the wear and tear, and then this incident that happened on April 21st was the final thing, and it busted. But there's not that causal connection, and Dr. Spear never gives that causal connection.
So in the one of the questions in the deposition is he's asked, some event appears to have taken this from merely wear and tear to something fairly significant. Is that right? Yes. Is that a combination of him having some degenerative pathology from the job in that shoulder combined with him pulling on this stuck rubber, in your medical opinion? Yeah.
Okay.
So is that not an...
No.
Why not?
5 times Dr. Spear says that everything that has to do with his bicep tendons is related to the acute injury that occurred on April 21st. 5 times. we start with, on page 9, and I get what you're saying, okay, but I want to point to these 5, try to point to these 5 things to say, to sort of undermine and clarify what he said then. On page 9, so all the information was fairly consistent with them having an original on-the-job injury that sparked that shoulder and started a series of treatments that eventually ended with Dr. Barnes performing the surgery. Original spark started. That's not combination. That's not going back to some condition before and ultimately being the cause. On page 37, which I think is just after what you just stated, well, I think that much of it, if not all of it, that's different than the quote that you, much of it, if not all of it, maybe something else contributed, but maybe or likely all of it was from the acute injury. Certainly much of it was from the acute incident because the symptoms were acute and his presentation was acute. And then he ends that with, so absent that injury, I'm not sure that his shoulder would have behaved like that. That's not a combination. Maybe it's a combination. And again, the full commission picked up on his testimony on page 11. Now, he certainly said it could have happened. What the scenario that you laid out could have happened. But he never said it happened. He said in general that this could happen, that it could lead to it. But when he specifically talked about Mr. Spencer, he said everything happened because of the acute incident.
Yeah, I mean, I'm going to ask your friend about that, because and there's certainly, I think, in Dr. Spear's testimony, there is some, there's a little bit of ambiguity about whether, you know, he doesn't state clearly the medical opinion that I referenced earlier. But if we're on competent evidence standard and we're trying to figure out in the Industrial Commission looking at all this and trying to piece it together, isn't that one statement where he seems to be asked pretty clearly, is this combination, in your medical opinion, is it the degenerative condition combined with the acute injury that causes? He says, yeah. Is that not competent evidence?
I don't think that you can just take, you know, and again, I know that the plaintiff cited that Alexander v. Walmart case where it says I can't go in and point out snippets of testimony and say, well, he agreed with me here. I'm not asking you to do that. I'm asking you to look at his testimony as a whole, specifically when he talks about the causation of what happened to Mr. Spencer's arm. And again, 5 times he says it was the acute injury. So I don't think I'm asking you to reweigh the evidence or just only look at this part without looking at, I'm begging you to look at the entire deposition as a whole and consider what is actually, does he ever give the causal connection? And I know you have a question. I'm going to specifically get to the causation in just a second. Yes.
And this is just to follow on what Judge Dietz has already asked you, but it may inform your further answer. When you say you're not asking us to reweigh the evidence, you're just asking us to look at everything that was said. If Dr. Spear, just for argument's sake, if through, you know, fate or good lawyering or preparation or whatever, Dr. Spear gave some testimony that supported the commission's findings. And 5 other times he gave testimony that contradicted that testimony. Don't we still have to affirm the findings because they're supported by competent evidence?
No, I don't. And I'll rely upon, and it kind of goes with what I'm saying is, you know, Holly, or Chambers says maybe is not good enough. Holly says could have is not good enough if you have other evidence that shows that it was a guess or speculation. And I've cited the Chambers Supreme Court brief in my case in my brief, but if you look at the Chambers decision from this court, the dissent from Judge Jackson, now Justice Jackson. Now again, I'm not saying that the Supreme Court did not adopt a dissent per curiam like they did Justice Hudson's in Alexander, but I think that tells you instructs this court that, yes, you are to look at the deposition as a whole. And if you have this snippet here, but it's clearly contradicted over here, then it's wrong. And you can't rely upon it. It's by its very nature would be speculative. So I would disagree with you, Judge Inman. I suppose, you know, I know that you can read that standard of review and get stricter and stricter and stricter, but if you say one thing here and you say one thing here, no, I don't think that if the commission picks this point, and again, when I point out to you, in general, he says this could happen. Specifically, he says it didn't happen. He says it all happened because of the incident. So the phrase, I think it's in 15 or finding of fact 15 or 17, where they say the bone spurs aggravated the ligaments, and then that caused the biceps tendon to become unstable. Again, a lot of that was from, they relied upon his testimony on page 11, but if you look at pages 23 and 24, so yes, just the wear and tear on the shoulder can cause those bone spurs to form. But I think what triggered the switch in his shoulder that made it painful, and following that strain was what Dr. Barnes found. He goes back and he looks, this is what Dr. Barnes found, that his biceps became unstable. The strain made the bicep tendons become unstable. Because the bicep tendon is stabilized in its groove with ligaments, and the biceps can get worn down from the spurs and all that. But, top of page 24, but if those ligaments ever tear and the biceps become unstable, which is what Dr. Barnes found, that's a sudden change of the shoulder, and it sounds like in reading his history that he had a moment or a time where he felt like he strained his shoulder, and from that point forward, his shoulder was more painful. He's not saying that the bone spurs wore down the ligaments and the ligaments made the bicep tendons unstable. He's saying, yeah, there's some wear and tear in his shoulder, but what made his bicep tendons unstable was this acute incident on April 21st. That is not what the full commission said he said. They described it as what you were saying. It's more gradual, it's all related. I'm not going to deny, and I cannot deny, that Mr. Spencer had bone spurs, and they were caused by the repetitive motion in his, from his work. Now, Dr. Barnes says they're not, but that gets back to your standard of review. I can sit up here and cry all day about Dr. Barnes is right. You can't listen to me even if I preach that to you. You've got to go with Dr. Spear. What I'm telling you is Dr. Spear didn't say what the full commission said he said.
So let me ask you while we're on the subject of that, Dr. Spear and Dr. Barnes here. So you also, so there's 3 parts to test for an occupational disease. Although the first 2 prongs of the statute, I think the case law has essentially collapsed into just a question of whether or not, you know, on the job you're exposed to this thing more than people generally. But one question I had about that is, so there is evidence in the record, I think this was Dr. Barnes, saying who do I usually see with bone spurs? Athletes and weightlifters and things like that. And then you have Dr. Spears saying, I studied Spencer's job, and he's exposed to this. But do you need some evidence to prove that ordinary people, that this is higher than, so maybe the general public, meaning, you know, just everyone that exists in the world, there's going to be people that, you know, don't really move around at all, that are very sedentary. There are other people that are very active in public generally. How does that work? I mean, do we have to consider the fact there may be lots of people who get this condition who don't have a job like this and are doing ordinary activities because they're athletes or weightlifters? Or do we just have to accept that, well, you take a baseline of a person that's not moving or doing anything, and that's the public? That's what I'm trying to figure out how we assess that.
I think that you look at, as best I can explain it, you look at the general public. Do most people, or does the general public, end up with these injuries? You know, I've got a bad shoulder. I don't know that it's near as bad as Mr. Spears, and, you know, I didn't get it at work. Or actually, I think I did get it at work, but it was 30-some years ago. But obviously, my job, I'm not doing that. So he's certainly exposed to a higher risk than I am. And then you look out at whatever the general public is. Now, it frustrates me as a defense attorney, but I do think that Dr. Spear, threw that out there. I think he's exposed more than the general public. So I think we may be stuck with that. I would love to argue he didn't know what he was talking about, or he didn't have the empirical evidence to base it upon, but that's what he said. And I think
That's sort of what I was getting at. So the way that we've collapsed the test in the case law, if an expert says, I said this job, in my view, I'm a doctor, but in my view, I think that what I watch this person doing at work, they're exposed to it more than, and that's game over then. And so really causation in these occupational disease cases.
no, it's not game over, because you still have to, and I interrupted you.
No, go ahead.
That prong may be game over in this case. I'll give you that. But the second prong, the substantial, this is in Rutledge too, the third prong, the significant causal factor. You've got to meet that. And that's what I've been talking about. He has not met the significant causal factor. The other important thing here is the occupational exposure. So whatever it's bone spurs, which I think is the only alleged thing that could be an occupational disease is the bone spurs. I have no idea what the ligament wearing is, or the general wear and tear. I don't think that's an occupational disease, but regardless, whatever's going on in his shoulder, the occupational exposure was such a significant factor in the disease's development that without it, the disease would not have developed to such an extent that caused the physical disability which resulted in the claimant's incapacity for work. I don't know where the evidence is that the bone spurs or all this stuff caused him to go out of work. What caused him to go out of work, which is what Dr. Spear said, was the acute incident. And I think this is the last one, but I certainly want to draw your attention again to page 27, and this is actually in the full commission's finding of fact. So again, this is what the passage that I think that follows the passage that you read at the very beginning, Judge Deeds. So again, page 27. Well, I think the demands of his job caused a lot of degenerative wear and tear in his shoulder, resulting in the bone spurs, and maybe some degree of biceps pathology. But the bicep tendon instability was probably caused by an event, a moment, some strain that thereafter his shoulder is uniquely more painful than it had been in the past. Maybe it caused the biceps pathology, but what caused the biceps to tear, to become unstable, was the acute event. And Judge Edmond, to go back to your point and to combine it with Judge Dietz's quote, those quotes aren't inconsistent. I'm not asking you to disregard what he said here and adopt what he said here. Those quotes are consistent. Yes, maybe there was something going on, but it wasn't the significant causal factor. So and I don't even know that it was going on. You're right, I think he says, your point was more clear. Here he's clearly saying maybe, but I think, again, in the end, he had some wear and tear, but this is what caused his injury, this event that happened on April 21st.
So the commission said the compensable injury was tendon tear in the left rotator cuff. So we have this testimony that that was caused by a combination of the degenerative wear and tear and then the acute injury. In your view, looking at that case law, is there more that an expert needs to say about, for example, saying that it was, in other areas of causation, we require some greater degree of tying it together than just saying like this and this in combination caused it. You have to say yes, and this was the contributing factor and not this. Is there a case law that says you had to show that the disease was the contributing factor and not the acute injury or anything like that?
The passage that I read to you in Rutledge, it has to be a significant causal factor. Without it, the disease would not have developed to such an extent that it caused the physical disability. This disease did not develop to the point where it actually caused the disability. It developed, but the acute event caused the disability. So that's what I would point to answer your question. And then Rutledge is pretty much it. That's the case law.
I have a sort of big picture question. We've all heard the phrase, the straw that broke the camel's back. How do we, in interpreting the Workers' Compensation Act, I think that Mr. Spencer's counsel is going to argue that you are making hair-splitting, hyper-technical arguments to deny him compensation. And what I hear you saying is, no, I'm saying that the commission made findings that weren't supported by Dr. Spear's testimony.
I would say that there's no evidence that this event on April 21st was the straw that broke the camel's back. And I know that they cited 3 cases about rotator cuff tears, and that eventually, the rotator cuff wore and wore and wore and wore, and then finally on the date of the incident, it popped. But I think that's vastly different in this case, and like I said, I think it's fairly clear those 5 passages that I pointed out say this was not the straw that broke the camel's back. This was the camel's back breaking. This was the tree that fell on the camel and broke the camel's back, not the straw at the end.
Right, I mean, and isn't, so just to take this metaphor, but isn't like your argument is the straw that broke the camel's back, which is the acute injury, is like the giant tree falling. But what they're saying is really there were just all these straws. It was not this straw that broke the camel's back. It was all these straws leading up to it. And what I'm struggling with is where I want to find the testimony that lets me know which of those two is right, so we can make this causal determination. So and I'm looking at the testimony, and what I just have is that one statement where he says it's a combination. Yes, that's
again. But then he comes back and he says maybe the occupational disease had some effect on the pathology, but what caused it was the acuteness. And again, when you look at maybe, when you look at could have, you're free to reject that as competent evidence. And so again, you're not going back and reversing the full commission's weight of the evidence. You're saying no, what you relied upon, A, is not supported by the testimony, and 2, what you're relying upon is maybe and could have. When he talks specifically about what happened to Mr. Spear, he's definite in it was this acute incident. So to answer your question, if you're struggling, all I can do is refer to those 5 passages, which I think are plenty to overcome it, but if you, that's all I got.
Does the commission's, exclusive authority to judge credibility of witnesses, weigh the evidence, all that, permit just for the sake of argument, if we were to agree with your interpretation of all of this testimony, if the commission interpreted it the way Judge Dietz is describing, is that within the fact-finding, the exclusive fact-finding authority of the commission to split those hairs, to decide that?
I don't think that it's splitting hairs, and I'll go ahead and give you the thing that you want that you can seek me on. If you go back and you read his testimony as a whole, and you think that a reasonable conclusion, and I would look at 23 and 24, that's what I'm saying is wrong and what the commission based it upon, and then that is bolstered, my argument is bolstered and proven by the 4 other passages.
Okay.
If you read his testimony as a whole, and you say, you know what, you could have interpreted it that way, it's a reasonable interpretation, then I lose. And what I'm doing is, what I'm up here begging you to do is, that's not what he said. And I've got these examples saying it's not what he said. If you disagree with that, and Judge Dietz, if you want to sit there and hang it all on that one passage that I've rebutted, I lose. You have to go back to the full commission. But you can read his deposition, and if you come to the conclusion, well, I think Dwayne was right, I don't think the full commission said what, or Dr. Spear did not say what they said he said, then I think you have full power to reverse it. I've got 6 minutes left. I'd like to have some rebuttal because I'm sure injury by accident is going to take some time. But if you have more questions, though, I mean, again, this is my argument. I'll be happy to answer them.
all right, we'll let you reserve it. Thank you, counsel.
Thank you.
All right, So we'll now hear from the appellee and cross-appellant on the second issue.
May it please the court. My name is Michael Burdix. I'm here with my law partner, Neil Kamak, and we represent Stanley Spencer in this workers' compensation case with Goodyear Tire and Rubber. The facts of this case aren't in any significant dispute. You heard defense counsel concede that Mr. Spencer's shoulder problems were caused by his job. That was actually one of the very first things that was conceded. You've also, I think, heard a concession on increased risk, that Dr. Spear offered testimony on the subject. You have both of those items. The standard of review is any competent evidence. I think this appeal is now decided by those issues because we have competent evidence in favor of causation. I mean, a concession is actually beyond what you need.
Well, here's my question about causation for you. The commission, and this is conclusion 4. Yeah, in conclusion 4 says, plaintiff has established by preponderance of the evidence that his employment exposed him to greater risk of degenerative wear and tear in the shoulders, above that seen in the public, and that but for plaintiff's shoulder strain, plaintiff would not have become disabled. But is that really, where is the findings that then lead to the conclusion that a significant factor in the injury, the compensable injury, was the degenerative wear and tear? This, what the only thing that could be the occupational disease, the bone spurs or these other conditions?
Your Honor, I don't think that the full commission specifically does that, and I don't think they need to. If you look at the other cases on these sorts of shoulder occupational diseases, I'm referring to Flynn versus EPSG, I'm referring to Gibbs versus Leggett, and I'm referring to Guerin versus Gladfelter. The commission in those cases went far less deeply into etiology than they did here, and it was fine. Those cases were all affirmed. Those occupational diseases were all found compensable. And I think looking at the facts of those cases shows why defendants are attempting something that is hyper-technical and that no case has ever done before in their bid to essentially roll back cumulative trauma occupational disease law. I mean, Flynn versus EPSG is, I think, particularly salient. There you had a camera operator who doesn't have any pre-existing problems that they know about, and then on July 20th, 2001, experiences this severe onset of pain, just doing their normal job, holding this camera up there. And they were diagnosed with a torn rotator cuff and a reactive synovitis. The plaintiff pled that claim in the alternative, just as Mr. Spencer did here, saying this might be an injury by accident, this might be an occupational disease, might be both. And it was approved on an occupational disease theory. And it was approved based on testimony that the plaintiff was at, quote, increased risk of shoulder problems. There was no need to go down in the weeds of, well, there was degeneration to this part of the AC joint, and that degeneration made the rotator cuff prone to tearing, and then they were doing their job, and then it tore. You had an acute event. You had the testimony on causation that was in very general terms, and you had testimony on increased risk, that they were at increased risk of shoulder problems. That was adequate to find the claim compensable, that was competent evidence to meet the plaintiff's burden. And
Yeah, but
you have
isn't
more
the, I think what I understand your friend to be arguing is the distinction here is that there is this defined acute event, although it may not have been an injury by accident. I think we'll talk about that in a minute, but something happened, which is the acute injury, and that what we're trying to figure out is if all the testimony from the expert is, yes, it's a combination of this, what we would call the occupational disease, so, what the bone spurs and all this, it's that and this sudden acute injury. Do you not need any testimony about how much of a factor those two things were? Is it just enough to say there's a combination? It's a mix, which I think Spears used combination. I think the commission used mix or mixture or something like that. And, is that enough? Just to say they're both in there together?
Your Honor, I think the paradigm here that the defendants are trying to ask you to use of trying to separate out that final April 21st, 2018 event from all of the other similar events that have preceded it is flawed. Cumulative trauma disorders are always going to have a series of events that occur over time, and then one day there's a problem. Sometimes that a problem occurs gradually, but there's still going to be a first event of symptoms. And what you saw in Flynn is there was a sudden occurrence of symptoms. If you look at Guerin, it was a slower development, but there's still going to be a first day of symptoms, a trauma where the disease manifests. We don't peel apart that final trauma and treat it separately from all of the traumas that preceded that. That's not how workers' comp law works. I mean, there's nothing in our statute that calls for that. There's no case law that calls for that. The defendants have not cited a single case that asks this court to treat that sudden, final, acute event differently from all of the similar events that preceded that. Remember, the undisputed testimony that we have here that was found as fact by the commission is that Mr. Spencer was encountering stuck rubber events every 5 or 6 skids. He's having a yank every 5 or 6 skids. He did 30 to 50 skids a day. This particular event on April 21st, 2018 is not substantially different from any of the other potentially as many as 10 events that he has on a regular day.
Maybe that's a good jumping off point to talk about your cross appeal.
Yes, Your Honor. We raised the cross appeal on the issue of injury by accident for several reasons. The first reason, of course, was to avoid a shell game theory of liability, where the defendants attempt to shift liability away from the advanced theory into the alternate non-pled theory. And what it has resulted in, of course, is this current posture where the defendants are trying to do both. They try to turn one claim into two. Our theory of liability and injury by accident is that if you use the ordinary definition of terms, which is what's called for by this case law from the Supreme Court, Edmonds versus Piedmont Publishing, the word accident does not equate only to the word unusual. There is some case law that has tried to reduce the question of accident solely to the question of unusual. If that is the case law that is followed, we freely admit we lose.
Well, would you, it seems like these two theories for you are contradictory because you just said, you know, he was encountering stuck rubber every 5 or 6 skids, day in and day out. This is occurring, and this is what supports this finding as an occupational disease. It's not like it's a straw that broke the camel's back. It's not a giant tree that broke the camel's back. Doesn't that cut against the concept? I guess you're saying that's why you're conceding that if the threshold is unusual, you concede that you lose
Absolutely.
on that. Okay.
Absolutely, Your Honor.
Okay.
At the same time, we would point to the fact that Goodyear specifically has a mechanism in the wig-wag machine and the application of the slurry that's supposed to prevent the sticking rubber events from occurring, has failed frequently, and that therefore this is an unlooked for and untoward event, even if it may not be an unusual thing.
Okay. To be unusual, it would be that that system worked all the time and then on this day it failed.
Yes.
Okay.
And if we use that paradigm of looking at the concept of unlooked for and untoward, which is recited in the case law repeatedly, even if it has not necessarily been applied as the sine qua non of injury by accident in recent years. Well, you look at those earlier cases and they're pretty clear that unlooked for and untoward counts, and you can look at the football player cases, Renfro versus Richardson Sports Ltd., where it's not unusual. The only thing that was unusual was the injury, and that was still, because it's an unlooked for and untoward event, to have a bad block where you break your wrist and suffer a career-ending injury. That was enough for it to be a covered injury by accident.
So is injury by accident and occupational disease in this case, are they mutually exclusive, or is there a theory under which both might apply, i.e. is there additional compensation, additional benefits to which your client might be entitled under an accident theory as well as an occupational disease theory? I mean, do you understand
I do.
what I'm...
Your Honor, whether this is an injury by accident or occupational disease, as long as it's one, the plaintiff gets the same compensation that they would get if it were both. And to answer your question, is there case law that supports an individual workers' comp claim arising and being characterized as both an injury by accident and an occupational disease simultaneously? The answer is yes. The case is Booker versus Duke University Medical Center. And that case, I think, really cuts to the heart of what you're looking at here. In Booker, you had an individual who got hepatitis from an accidental needle stick. The accidental needle stick is an accident. It's not supposed to happen. The plaintiff gets infected as a result. So the hepatitis in that case is the consequence of the injury by accident. On the other hand, hepatitis is also an occupational disease because the likelihood of contracting hepatitis in that job is way higher than it would be for the general public. So with the hepatitis as an occupational disease, you look at more than the needle stick. You look at the overall exposure, and you have the causation and increased risk there as well. With occupational disease theories of liability, you don't look at just one event. You look at that last event and everything else that preceded it. With the injury by accident theory, you just get to look at that last event. But you can still have something be both. And Booker talked about that, saying how back before the amendment to make occupational diseases more liberalized in the 70s, where we got the catch-all provision, occupational diseases were very, very tightly defined. They had to develop gradually, but that changed. And what defendants are trying to do here is try to resurrect some of those older principles by asking that you not consider this final acute event as part of the overall scheme. They're asking you to find a way to take an injury that was caused by the job. They admitted it. And that he was at increased risk. They've admitted it. And say that's somehow not compensable.
Well, what if, getting back to the causation question, what if so there's a torn tendon in the left rotator cuff, and if an expert testifies, yes, this employee had bone spurs and other degenerative diseases that could be considered occupational diseases, but having looked at the accident, what happened? This worker would have suffered that same torn rotator cuff injury, regardless of whether or not you had the degenerative conditions as well. Because I'm looking on the camera of what happens, and yeah, anybody doing that would have had a torn rotator cuff. Does that defeat the causation requirement in your view then? So in other words, the testimony is it wouldn't have even mattered if you had this occupational disease, you would have suffered this injury. In that case, under Rutledge, can we say, well, you can still, if you say that it was that contributed in however tiny way, then that's enough? That's the question I have.
Your Honor, in that postulation, you have a premise, essentially, that the job caused the injury. That is causation. The fact that it occurred suddenly as opposed to occurred as a result of a series of traumas over time is superfluous because the law doesn't care. There's no case law that the defendants have cited that care about that subject. That is something that defendants are asking you to add to the law without authority to do so.
But I guess what I'm struggling with, if that's correct, is so if the exact injury would have happened regardless of the occupational disease, how could we possibly say that the occupational disease is a significant causal factor? And that's, I thought, what the Supreme Court told us we do on the third step of the test.
The occupational disease in this case, let's define precisely what Mr. Spencer's occupational disease is, because I think that may answer this question. Mr. Spencer's occupational disease is not one diagnosis. In fact, this court in Johnston versus Duke answered that specific question when I was on the other side of this issue. In Johnston, we tried to essentially propound this theory that you look at individual diagnoses and each is a separate claim, each is a separate occupational disease. So in that case, we had plantar fasciitis was one occupational disease. And then later, Achilles tendinopathy, which a lesion that appeared on the Achilles tendon. It's a totally different part of the foot than the plantar fascia. And then later on, nerve inflammation, the tarsal tunnel became problematic. And so we tried to bring that as a third occupational disease. And the court said, no, that is not how this works. The occupational disease is all of this, the foot problems. That's what we have here for Stanley. He has the shoulder problems, the bicep problems. It's all one thing. Yes, you can look at the individual components and say, yeah, they're bone spurs first, and then ligament damage and wear and tear. He has glenohumeral arthritis, which is the ball and socket. He has AC joint arthritis, which is the bone spurs on the top of the shoulder. He has the tear of the rotator cuff, specifically the supraspinatus tendon, little on the top, little on the bottom, the bicep tendon scarring and all of that. you could thinly subdivide all of those things apart. But that's not what workers' comp law is about. Workers' comp law is not medical ICD-10 sub-delineations that are each handled individually. We handle all of this as one thing, and that's what we've done here.
But I guess I still don't think you've answered my question, which is if the expert had said, yes, so all of those things you described, and yes, and I think that's all one occupational disease. And, but there was this acute injury that caused the worker to become symptomatic. I'm now watching the video of how that happened, and I can see, because when you put your shoulder like that and pull on rubber like this, you're going to tear your rotator cuff. And I got to say, the injuries, all these symptoms, it wouldn't have mattered if you had this occupational disease, all the bone spurs or not. Anybody doing that would have suffered these same injuries. I mean, would you acknowledge that in that case you can't have an occupational disease recovery in the Industrial Commission? I mean, certainly there's no causation. If those things hadn't, whether you had it or not, you would have suffered the injury. Or do you disagree with that?
I would disagree with that, Your Honor, because remember, Mr. Spencer did this 10 times a day. And so it's not true to state that anybody who did this would suffer a shoulder tear, because he obviously did this for 6 years.
Well, wait, but you're rejecting my hypothetical. But
Right.
I'm in my hypothetical, though.
Okay.
So forget our case. And where an
Okay,
expert's
I
saying, so imagine that were true, the expert's saying, yes, this would have happened, regardless of whether there's any degenerative issues. Anybody that did this would have, then would you lose on causation in an occupational disease claim?
Okay, so if you have an event that is so significantly traumatic that an expert would look at that and say, if you did that, you will tear your body, then the answer is that is an injury by accident, because it necessarily would be something that can happen one time, and therefore it's unusual and there's no question.
But you're saying it's not an occupational disease, because the person said you do have all the degeneration, you have all this, but anybody doing this thing would have suffered. Do you agree? Because let me just take it to the next step. I mean, if we eventually get to that, if it would have happened anyway, the exact injury, then my question is, how much of a connection between the occupational disease and then the resulting compensable injury does there need to be in the record? So, does the expert need to say it's, that this was the contributing factor? Does it need to be, it was a significant factor? Can it just be, it was in the mix? It was, because that's what we've got here in the testimony, is it was a combination. It was in the mix, but nothing about how much the actual injury caused, or the event that, the pulling of the rubber like that suddenly caused acute injury. How much that led to the compensable injury versus how much was the bone spurs and the other disease. Are you following what I'm saying?
I am, Your Honor. And I think the answer on that is our case law looks at contributing factor. If it's a contributing factor, then it's covered. I mean, if we address the hypothetical of just taking out injury by accident theory, suppose the plaintiff doesn't plead that as an option, okay? And you just have an event that occurs on the job that someone needs to do because it's on the job, that they get assigned that by their employer. Okay? It's a singular event, and it's so significantly traumatic that an injury was inevitable. I would have a hard time arguing that that wouldn't also be compensable as an occupational disease. And the reason being is that Rutledge and Booker have said that the definition of an occupational disease is you have causation, you have increased risk. By this definitions of this hypothetical where you have a singular acute event, still looks like causation and increased risk. I mean, it's actually part of the premise. At that point, doesn't the case law constrain us? I don't know of any cases on the other side of that.
Well, see, this is what I'm struggling with, because we also have that. So, for example, in fundamentals of tort law, like negligence, you have duty, breach, and causation. But it turns out it's not just, this thing was in the mix of other things that caused it. We have this very complicated test that we call proximate causation, and that helps you determine whether that, and that's what I'm trying to figure out is there some legal standard like that we can look to in the case law to say, how do we take what Spears testified to, which is, it's not a whole lot, but he says this was a contributing factor, and then from that say, therefore, the conclusions of the law the Industrial Commission made are are okay?
Workers' compensation law does not apply strict negligent tort principles of proximate causation. Instead, the concept that we have is the idea of natural and probable consequence, where anything that flows from the injury, regardless actually of whether it's foreseeable or not, if you've got causation in fact, it can come within the ambit of the claim. It's a little bit more permissive than the tort concepts with approximate cause.
Yeah, but I didn't see a case applying that to the causation element in the occupational disease test. I mean, is there case law that's done that?
Precisely on that question in this context, no, not that I am aware of.
Well, what would you say, what do you think we should say the test is then?
What I would say, I would turn to the intent and purpose of the act. It is the intent and purpose of the act that industry be required to take care of their own wreckage. There is no dispute that Mr. Stanley Spencer is the wreckage of this industry. He was doing a task that caused him to tear his shoulder, tear his biceps tendon, and that put him at higher risk of that event happening and of that pathology arising. That does not appear to be disputed any longer. Well, if he's the wreckage of industry, and this is what the case law says, where you have causation and increased risk, how are we coming to a conclusion that this is not supposed to be covered? I mean, if that's the case, then we've arrived at a place where the law says that it is okay for industry to treat human beings like parts to be thrown away and replaced. If the industry just causes them to break down one day in catastrophic fashion. And Your Honor, I think that that is not something that any of our case law supports. And it is not something that is consistent with what this court and the Supreme Court has tasked the Industrial Commission with affecting in workers' comp. With that, I'll reserve the remainder of my time. Thank you.
Thank you, counsel. Rebuttal?
All right, thank you again. I think I just have some brief points to make and be happy to answer your questions. One is I'm a man of my word. I kept telling you 5 instances. The 5th one is on page 28 in response to what happened with pulling on the stuck rubber. Spear testified, "It seems very logical to me that the mechanism of injury, the pulling on the rubber, could be responsible for his biceps tendon injury and then triggered." Again, triggered, that goes back to the start, the spark. That's not relating back, that's starting all the clinical care he had thereafter, including his surgeries. I think that I've answered this before about the cumulative trauma leading up to the injuries. I just don't think there's evidence of that here, and I think Spear explains that I understand that he was using his shoulder constantly. Pulling the stuck rubber was, difficult, and that caused bone spurs. But there's no evidence that cumulative trauma led to the disability.
So, I don't want to get you off track, but that's one question. So I think what the commission did, I'm trying to figure out what the legal test for causation is, the correct one here. The standard that the commission cited was like a but-for test about the employment, something that doesn't really seem to fit here. So that what the commission says on the causation element, you look at but for the employment, would the person have suffered this? But the problem we have in this case is that it was 2 things that arose from the employment that caused it. One was an acute injury that's not an occupational disease, an acute event, and then the other was the occupational disease. So if the commission never made findings and then a conclusion about something, what do we do as the Court of Appeals? If we think there is a legal test and they never used it, what's our remedy?
I think if you determine that they misapplied the law in some manner, and you can't resolve the facts, and sometimes this court does resolve the facts, and I don't know that they should, but if they have somehow misapplied the law, if they have written out the law and you go, that's not the law, then you remand it back and you tell them what the law is that they have to follow, and you make them then look at the facts and weigh it. You know, and you may have to do that with what I'm saying, but I think what my argument is, if you buy what I say, you say they misapplied the law, or actually, maybe the causation law, but, they misapplied the facts, and they stated something that, they said, Dr. Spear said something that he didn't say. So I think you could correct that one. But again, if it's this test,
Well, do you think there's a test for that third factor in a case like this where you're trying to figure out there's multiple things happen in the workplace?
I look at it as, and I'm going to fall into the trap of what Mr. Burdick said I was doing, but anyway, I do look at it as, I think you have to prove one or the other or both. You can prove both. And I think here it's clearly not an injury by accident. And so did plaintiff prove that the occupational disease was a substantial contributing factor to his injury such that it caused a disability? I'll repeat, I think that's the test.
And if that is the test, and the commission in its conclusions of law never said that, do we just, since it's a conclusion of law, do we just have to say it, right? But if we think that there's facts that need to be resolved, if that's the test, then we have to send it back. Is that your position?
And I think that if you agree with me that that's what okay, again, Dwayne's right, that's what the law should have been. The full commission should have applied it. If you can then say, and if they applied it, the facts lead to only one conclusion, it's not compensable, then I don't think you have to remand it back. But if they applied this test and it kind of affects the facts that they found, so we just need them to do it again, then I think you would remand it back.
Let's get to injury by accident real quick and give you a chance to address that. Your general argument, as I take it, is that these things get stuck all the time. It's part of and the employees have figured it out. But there's also evidence that wasn't supposed to be the way it is, and that the employees had complained about this, and this was something this was just part of the process that was wrong, hadn't been fixed despite complaints over years. So I guess the question is, just because something happens, it's sort of an accident waiting to happen, in a sense, that that this was not part of the normal process, or should not have been part of the normal process. I mean, does it have to be just this one-time event, or could it be something that an employer has put in place or refused to fix that can lead to an accident?
The case law tells you very clearly that if you do something, that even if it causes exertion, even if something happens over and over again, it can become part of your normal routine, and that's what the full commission found.
Okay, so then in that case, why is this case not jurisdictional? Because there's, as you say, there's no dispute that this was something that was caused by something at work. If it's not an occupational disease, if it's not an accident because it's something the employer is requiring them to do, whether the employer should or not, why doesn't this fall outside of the exclusivity provisions of the workers' comp, and why shouldn't we just allow the plaintiff to pursue a negligence case against Goodyear here?
In 20 seconds, 100 years of the act, there was a compromise, and there is an exclusivity act. If you get hurt at work, you get paid if it falls underneath the act. If it doesn't fall underneath the act, you don't get paid. I mean, that's Judge Hampson, that's kind of a huge question. I'm not sure the authority.
That was one of those unfair questions that I asked with 20 seconds left in your argument.
Yeah,
I accept
it was.
that. Yeah. Yeah.
No, I don't think that. I think this is a workers' comp case. It's at the Industrial Commission. If they don't find an injury by accident or an occupational disease, then you don't get benefits outside of the Industrial Commission. And if I can have 15 seconds, and I can't explain it, but Judge Dietz, you kept referring to rotator cuff, and I know that's in the conclusions, but when you look at the deposition, that's not the injury we're talking about, it's the biceps tear. And I
just assumed
I'm
not a kinesiologist or whatever, so I assumed it's all connected up there.
Well, he did have a rotator cuff tear, and that's where it gets a little confusing. Mr. Burdick can come up here and blow my argument out of the water, but I think he had some tearing. Dr. Barnes saw some but didn't do anything, or anyway, when it got to Dr. Spear, it was worse, and Dr. Spear did something. My statement is there's no evidence that caused any disability, but I just wanted to bring to your attention, rotator cuff is mentioned in Spear's deposition and in the opinion and award, but I don't think that's the injury we're talking about. Thank you.
Thank you, Counsel. Second rebuttal.
I think it's important to come back now to the standard of review. We have an anti-competent evidence standard. It's very permissive. Page 38 of Dr. Spear's deposition, he's asked whether the acute event and the wear and tear contributed collectively to the biceps tendon tear, and he says yes. I think that's the end of it. I mean, if he says more likely than not, that has been found under Hawley versus Axe and Young versus Hickory Business Furniture to be sufficient. It's competent evidence to meet plaintiff's burden.
Yeah, certainly, if we think the legal test is, you just need
Yeah,
a little bit. But what if we think, what if it was 1% the occupational disease and 99% the acute event? We think that's not enough. So the standard is you have to show that the occupational disease was some substantial or significant factor or something. Then it's a little bit more complicated. But
Well-
I take it you're saying no, you don't have to do that. You just need evidence that it was one of the contributing causes.
Yes, and Rutledge says that. I mean, Rutledge, in a lot of these early occupational disease claims, all involve the same kinds of occupational disease, specifically smoking and COPD and bisonosis. And the reason that matters is because in these early cases where this, actually the Supreme Court largely grappled with how much causation is necessary, they had to deal with the fact that in these mill towns, the people who were going and doing this mill work and were breathing in all this cotton dust also smoked to a person. And there would be conflicting testimony that, you know, oh, it's either all or a substantial part of it is from the smoking, not just the cotton dust. And, you know, in Rutledge, the answer was, well, if it's a factor, it's enough. There was not a particular percentage factor that it had to be. It didn't have to be the majority factor. It didn't have to be anything other than just a significant factor.
And I think that's part of what the full commission's struggling with in this case, is it's not even a question necessarily of, is it occupational disease or not? It's, you know, is it occupational disease or is it acute injury at work, setting aside accident? And that seems to be, you know, and obviously statutorily, we're kind of want to put it in one bucket or the other, right? And so I think the question becomes, what do we do in that gray area? What is the causal test? What is the proper analysis that the commission's supposed to apply? What's the test when it could be either one? And you know, and how do we articulate that test?
Johnston versus Duke answers that and says you don't separately consider that final event separate from all the other ones. Yeah, there was a final event, sure, no question. I mean, that happened. But that acute event is part of the occupational disease. It is not to be considered separately from it. Plaintiff filed one workers' comp claim. The claim was pled in the alternative as either consider that April 21st, 2018 event as an injury by accident, or consider all of the trauma from his work generally as an occupational disease. That doesn't exclude that final event. And the defendants have yet to come up here and cite to a single piece of legal authority that calls for considering that April 21st, 2018 event separately from all the rest. Not one case. Nothing. There's not one case. And that's because if you look at cases like Flynn versus EPSG, there was a similar event. There was that event that happened at the end. And it was considered as part of the overall occupational disease. You had that in Gibbs versus Leggett, where you have the guy who's pushing the big, he's a tiny guy, like I think under 5 feet or something like that. He's pushing this large industrial buffer around, and his shoulder starts hurting one day. You don't separate out that event from the rest of it. If you were to shave off the final cumulative trauma that preceded disability from the rest of the claim in every occupational disease claim, there would not be cumulative trauma claims anymore. Defendants are asking you to do something novel. They are asking you to do something for which there is no pre-existing authority and which is essentially a surplusage or in addition to existing law of occupational disease. And I would submit to you, Your Honor, that going and doing that is contrary to the intent and purpose of the Act for industry to take care of its own wreckage. Thank you very much.
Thank you, counsel. We'll adjourn.
This session of the North Carolina Court of Appeals is adjourned.